If you are watching this right now, and your green card interview is coming up, stop what you are doing and pay close attention to every single word I'm about to say. Because what used to be one of the most hopeful days of an immigrant family's life, the final green card interview, has now turned into something that no one ever expected. Something that immigration attorneys across this country are calling unprecedented. Something that is tearing families apart in real time. This is not a scare tactic. This is not political commentary. This is what is actually happening on the ground right now in 2026. And if you or someone you love has a green card interview scheduled, you need to know every detail of what I am going to share with you today. Beginning in November 2025, ICE agents started arresting applicants during routine marriage-based green card interviews at USCIS field offices. A practice that immigration attorneys describe as unprecedented, a dramatic departure from decades of agency norms. Let that sink in. Routine, marriage-based, green card interviews. These were not criminals. These were not people who had ignored the system. These were people who had done exactly what the government told them to do. They filled out the paperwork. They paid the fees. They gathered the documents. They showed up. And then ICE walked in. Witnesses described scenes of confusion and distress. Applicants, many of whom believed they were on the final path to legalization, were taken into custody by ICE agents inside the very USCIS facilities where they came to get their green card. So let's talk about exactly how this started. Who is being arrested? Why the law is not protecting people the way many assumed it would? What the courts are doing about it right now in 2026. And then, most importantly, the 3 concrete things you can do today to protect your family. Let me take you back to November 12th, 2025. That is the date when everything changed. Immigration attorneys started reporting detentions on that exact day, the day before a reported internal ICE memo authorizing such operations. The first cases came out of San Diego. People started talking about it on Reddit. WhatsApp groups for immigrant families exploded with messages. TikTok videos started circulating. At first, many people thought it was a rumor. It was not. Since November 12, 2025, ICE agents have detained spouses of U.S. citizens at USCIS offices immediately following green card interviews. The first documented cases emerged from the San Diego field office, where attorneys reported dozens of arrests within a matter of weeks. Similar arrests have since been confirmed in Cleveland, New York City, and Utah. 4 cities. Real people. Real families. And who exactly are we talking about? A British mother, arrested while holding her infant. A Ukrainian refugee who had fled war, arrested. The wife of a retired United States Marine, arrested inside a federal building where she had come in good faith to finalize her legal status. Retired Marine Staff Sergeant Samuel Shasteen described the moment his wife was detained. He said, "I kind of feel betrayed." He said this after ICE agents entered the interview room and handcuffed his wife in front of their family. A man who served this country, who risked his life. And he felt betrayed, not on the battlefield, but inside a government building. Then there was a man in San Diego who entered the United States legally as a child. He overstayed his visa after marrying a U.S. citizen. He went in for his interview. The officer reviewed his case and told him, "Your case is perfect, approved." And then ICE arrested him. There was a woman in Cleveland who had lived in the United States for 25 years. She was detained during her interview because of an old removal order from her parents missing a court date years ago. Not something she did. Something connected to her parents. And she had no idea that order even existed. This is the world that immigrant families are navigating right now. Now, the question everyone is asking is, how is this legal? How can ICE walk into a USCIS office and arrest someone who came in for a scheduled appointment? Here is the legal reality that most people do not know. There has never been a federal law that protects applicants at USCIS offices. The no ICE at interviews assumption was custom, not statute. ICE always had the authority to arrest inside USCIS offices. 2025 is simply the first year ICE is using that authority aggressively. USCIS and ICE now share interview attendance data in real time. USCIS staff cannot warn you that ICE is present. ICE is increasingly using undercover officers at interviews, so by the time you walk into that building, ICE may already know you are there. The officer sitting across from you during your interview may be an ICE agent, and the USCIS staff member who greets you cannot legally tell you what is waiting down the hall. Now, many people think, okay, but I am married to a US citizen. That protects me. Or, I have a pending I-485 application. That protects me. Or, I only overstayed my visa. That is just a civil infraction. They cannot arrest me for that. Here is what is actually happening right now. Overstay forgiveness does not protect you. Marriage does not protect you. Your U.S. citizen spouse cannot stop the arrest. Your pending I-485 does not prevent ICE from intervening. In 2025 and 2026, overstays, which were once forgiven for spouses of U.S. citizens, are now being treated as active grounds for ICE detention. The law on the books has not changed. The enforcement has. And that gap between what the law says and how it is being enforced is exactly where families are getting caught. Think about what that means for a moment. The entire point of the Provisional Waiver Program, created in 2013 and expanded in 2016, was to encourage undocumented spouses of U.S. citizens to come forward and fix their status legally. The government said, come in, go through the process, follow the rules, and we will work with you. Now those same families, who did exactly what the government asked, are being arrested for showing up. And the chilling effect is already happening. Immigration attorneys are reporting that clients are terrified. Many are skipping their interviews altogether. One lawyer said people feel like they are walking into a trap, pushing them away from the legal path. When people are too scared to attend their legal immigration appointments, they are forced further into the shadows, and that is a direct consequence of this policy. Now let me tell you what is happening in the courts, because this is where things are moving fast. There's a lawsuit that goes back years. In November 2018, the ACLU filed a federal lawsuit on behalf of Wanrong Lin, a father of 3 from Maryland, who was arrested after attending an interview to validate his 14-year marriage to his wife, a U.S. citizen. Other Maryland families came forward with the same story. The cases were consolidated into a class action lawsuit in 2020. In 2024, a federal judge ruled in their favor, prohibiting the Department of Homeland Security from arresting, detaining, or removing people who are in the process of applying for the Provisional Unlawful Presence Waiver. The federal government appealed that ruling. And now, in February 2026, the U.S. Court of Appeals for the Fourth Circuit heard oral arguments on whether to overturn it. Government attorneys argued that individuals with final orders of removal have no legal right to remain in the United States, and that the Provisional Waiver Program provides no protection from deportation. Attorneys with the ACLU of Maryland called it a bait and switch. The government invites you in with your U.S. citizen spouse, tells you to come finalize your legal status, and then arrests you when you show up. The Fourth Circuit's ruling would affect Maryland, Virginia, West Virginia, North Carolina, and South Carolina. A ruling against the government could solidify protections across those 5 states and inspire similar lawsuits elsewhere. But as of today, the ruling has not come down yet, which means that for most families across the country, outside of those 5 states, there is currently no court order protecting you. And even in those 5 states, the protection could be lifted depending on how the Fourth Circuit rules. So what do you actually do? Here are the 3 things that can genuinely protect your family. The first thing, do not attend any green card interview, especially a marriage-based one, without first having your case screened. by an experienced immigration attorney. Not a notario, not a friend who knows someone who went through the process, an actual licensed immigration attorney. Having a lawyer screen your case reduces your risk more than anything else. What does case screening actually mean? It means a lawyer goes through your entire immigration history before you walk into that building. Attorneys can request records from the government, check for unknown removal orders, and assess whether ICE may have flagged your specific case. This is critical, because many people do not even know about removal orders sitting in their file. That woman in Cleveland had no idea that an old order connected to her parents existed. A lawyer can find that order before you walk in. A lawyer can sometimes file motions to address outstanding orders before the interview ever happens. A lawyer can tell you, based on your specific situation, whether attending right now is the right move or whether there is a safer strategy. Do not cancel your interview without legal advice. That has its own consequences. But do not walk in without preparation either. The days of treating a green card interview as a formality, as something you do on a Tuesday and celebrate on a Wednesday, those days are over for now. Get an immigration attorney involved in your case immediately, not when the interview is a week away. Now, the second thing, build a family emergency safety plan before your interview date, not after. Every critical document needs to be copied and stored somewhere your U.S. citizen spouse or a trusted family member can access immediately if you are detained. This means your passport, your I-485 receipt notice, your marriage certificate, your birth certificates, your children's documents, any financial records showing your life together in the United States. Your U.S. citizen spouse needs to know exactly what to do in the minutes after an arrest. Family members can help by gathering documents and forwarding them to your attorney. They should know how to find you through the ICE detainee locator system. They should understand how to request a bond hearing on your behalf. Have an immigration attorney's emergency contact number saved in your phone before you walk into that building. Not someone you plan to call eventually. Someone you can call in the next 5 minutes if things go wrong. And this next part is critical. Do not sign any immigration documents until an attorney has reviewed them. Some forms may waive your rights. Some may agree to voluntary departure, which sounds minor but can have consequences that follow you for years. People are signing documents in shock immediately after an arrest without understanding what they are agreeing to. Do not sign anything without talking to a lawyer first. The third thing, understand and exercise your rights from the very first moment of any contact. This applies regardless of your immigration status. You have the right to remain silent. Politely decline to answer ICE questions without an attorney present, except for basic identifying information like your name and date of birth. That is all you are required to say. Your name, your date of birth, nothing else. You have the right to speak with an attorney. Say clearly and calmly, I am exercising my right to remain silent. I would like to speak with my attorney. And then stop talking. Do not answer questions about where you entered the country. Do not answer questions about where you have lived. Do not answer questions about your immigration history. This is not being difficult. This is not being uncooperative. This is using the rights that exist to protect you. Rights that every person on American soil has, regardless of their status. Anything you say during an encounter with ICE can and will be used against you in immigration proceedings. The less you say without counsel present, the better your position. Now let me take a step back and give you the bigger picture, because this situation is still evolving. The 2025 and 2026 arrest wave at green card interviews is not a rumor. It is a documented trend. The law may still forgive overstays for marriage-based cases, but enforcement practices no longer do. The system that immigrant families relied on for decades was built on an understanding, an unwritten agreement between the government and families, that if you followed the process, you would be safe while you followed it. That understanding has been broken. Legal experts are warning that this approach effectively weaponizes the legal immigration process against those who are simply trying to regularize their status. A policy designed to keep families together is now being used as the mechanism to tear them apart. The Fourth Circuit will eventually rule. Other courts will weigh in. Congress may act or may not. But while all of that unfolds, real families have real interview dates on the calendar, and they cannot afford to wait for the legal system to catch up. So here is where I am going to leave you. The British mother holding her infant. Real. The retired Marine's wife in handcuffs. Real. The man whose case was approved before he was arrested. Real. The woman detained because of a court date her parents missed years ago. Real. And the court battle happening right now, deciding whether USCIS interviews remain a place for adjudication or become a permanent enforcement venue. That is real too. Until that question is answered, and honestly, even after it is answered, the most important thing any immigrant family can do is be informed, be prepared, and refuse to walk into any government building alone without understanding exactly what they might be walking into. Get a lawyer involved now. Build your safety plan before the interview date. Know your rights before you walk in the door. And please, share this video with every family you know who has a green card interview coming up, because the one thing more dangerous than this enforcement environment is not knowing it exists. Information is protection, and right now, your family needs both.